You want to know one of the biggest mistakes attorneys make when questioning a doctor during his pretrial deposition? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury and that your injury is significant and permanent. And now, you have a valid expert, you have a medical malpractice expert who's reviewed your records, who's determined that you do have a valid case. So now you go forward with a lawsuit against the doctor whom you believe caused you significant harm and injury. During the course of your lawsuit, your attorney will have an opportunity to question your doctor. Now, why is that? Because we have an opportunity to get the doctor to answer questions that we put to him. This is known as a pretrial question and answer session. Legally, it's known as a deposition. Now, you should know, this takes place in the defense lawyer's office. Actually, it takes place in his conference room. There's no judge present, there's no jury present, but there is a court stenographer there to record all of our questions and all of the doctor's answers. Now, some people may think, hey, since this is such an informal place, then what the doctor says doesn't really matter. Actually, that's not true. What the doctor says in his answers constitutes the same exact testimony and carries the same exact weight as if he were testifying at trial in front of the judge and in front of the jury. Most attorneys, when they question a doctor, they've been taught from the beginning when they started their careers, listen, when you go ahead and question a doctor during his pretrial testimony, you are going to ask him questions about his credentials, such as, doctor, where did you go to college? Where did you go to medical school? Where did you do your internship and training and your residency? Are you licensed to practice medicine in the state of New York? Are you board certified? Did you do any type of fellowship? That's credentials. And you know what? That's total bull. You want to know why? It's because every attorney who goes in to question a doctor during a deposition should already have that information. They should already have done the research so they know exactly where he went to school. They know exactly what training he received. They know everything about him. That information is not very relevant or very important yet. We get to it. I get to it. However, attorneys who start out that way have the mindset of, okay, I got to do things step by step by step by step in order to achieve my objective. And again, I say that's total bull. Let me tell you why. In my opinion, I think the better practice is to do what's known as a pattern interrupt. Now, that's a psychological term that basically distracts the doctor or throws them off track. Why? Because they're not recognizing, they don't realize, they're not thinking about the issue I'm going to hit them with right away. In my opinion, it's been my practice and my experience that the best way to start off a question and answer session of a doctor whom you have sued is to ask the doctor the most critical question in the whole entire case as my very first question. Now, you might be thinking, how can you do that? I'll tell you how. Let's say, for example, this is a case where the doctor operated on the wrong side of the brain. And my very first question is, doctor, why did you operate on the wrong side of this patient's brain? Now, in response to that question, the defense attorney is going to jump up and yell out, objection, you can't ask that question. Now, if he gives me that type of objection, there are two reasons why he's doing it. Number one, it's because the attorney is not prepared for that type of question so quickly. Number two, the doctor is not prepared for that question so quickly. In all likelihood, the attorney has already prepared the doctor for the types of questions that I'm going to be asking him. That's known as a prep session or preparation session. And when you hear me say the doctor is being prepped or prepared for his question and answer session, I'm not suggesting that the defense attorney puts words into the doctor's mouth. Instead, the defense attorney will go through the medical records with the doctor to refresh his memory about what he did, what the patient did, what they said. And then he'll ask him hypothetical questions that I will likely be asking him. But the problem is that so many attorneys, both plaintiff's attorneys and defense attorneys, follow this rote mindset that says, hey, we have to start asking questions of a medical doctor by asking his credentials first. And I say that's absolute nonsense. You don't have to ask that first. So when I ask that critical question, doctor, why did you operate on the wrong side of the brain? He has to answer that question. Now, the defense lawyer may turn around and say, counselor, there's no foundation for that question. And at that point, I have one of two options. I can argue with the attorney about why I don't need a foundation, and a foundation simply sets the scene and establishes a few basic questions before I ask the critical question. And I'll give you an example in just a moment. Or, number two, I can change the wording of my question around. And by the way, I can ask a question 10, 15, 20 different ways, so I don't have to deal with fighting over the objection. Now, what am I going to do? I'm not going to fight with the attorney over the objection other than to say, counselor, can you show me where it says, anywhere, that says I have to ask a foundation question first before I ask the most critical question in the entire case? And he'll be like, and he won't be able to give me an answer because there is no answer. Instead, I've thrown him off guard. I've thrown the doctor off guard. So now, here's the foundation question that I was talking about. A foundation question, if he's arguing with me and says you need a foundation first, what I'm going to do is say, okay, doctor, isn't it true that on January 1st you had a conversation with my client? Yes. And the purpose was to determine whether or not she was a candidate for this surgery. Isn't that true? Yes. And it was your intention to recommend that she have surgery on the right side of her brain. Isn't that true? Yes. And in fact, she agreed to have surgery on the right side of her brain. True? Yes. And she signed a consent form to have surgery on the right side of her brain, right? Yes. Explain to me, doctor, why on January 5th you did surgery on the left side of her brain. Right? Those questions establish a basic foundation. It establishes the scene. It establishes that my client was the doctor's patient, that he agreed to operate on one particular side of the brain, the patient agreed to have surgery on this side of the brain, and now he went ahead and operated on the other side of the brain. And now I'm asking him to explain. That's the most critical question in the whole entire case. And I'm entitled to ask that as my very first question. And that whole nonsense about asking about the doctor's credentials, yes, I'll get to it. There's no big secret here. I know his credentials, the doctor knows them, I have his CV, I'll get his CV, not a big deal. You know, I realize you're watching this video because you do have questions about your own particular matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.